little discussion they have about implied powers in the necessary and proper clause about this bank. So I'm curious.
Yeah, just a
how does that play out?
Great. Well, I will
Part two.
Share my screen again, and we're on to part two. So if I began in the first part by talking about really the first constitutional debate that consumed the first Congress, as I was talking about in one of the breakout rooms. Congress is gavelled into session in April of 1789. It's mid-May of 1789 when the removal debate begins. So this is really the first debate, the removal debate. Now we're going to talk about the final debate that the first Congress has, the bank debate, which takes place in the closing weeks of the third and final session of the first Congress in 1791. So to an even greater extent, I think, than the removal debate, the bank debate demonstrated the fundamental nature of early constitutional debate. These were not narrow interpretive debates. They really forced congressmen to consider what, in a more general sense, the Constitution was and what they, as the nation's political leaders, ought to do with it. So the removal debate had focused on the problem of constitutional silence. The bank debate focused on a different problem, the scope of national power under the Constitution itself. So the National Bank, as I'm sure many of you know, was part of Secretary of the Treasury Alexander Hamilton's ambitious and controversial plan for remaking the nation's finances. The first parts of that plan, which called for the national government to fund the unpaid national debt and to assume the unpaid state debts, had begun dividing the nation's leadership class along ideological and regional lines. But the next part of that program, which he unveiled in late 1790, which called for the national government to charter a national bank, this really finished the job. So if the first part of Hamilton's financial plan had begun fracturing the leadership class, the national bank put the final nails in the coffin and really paved the way for the nation's first political party system. So Hamilton's plan, and especially the bank, really upset those like Secretary of State Thomas Jefferson and his good friend and fellow Virginian James Madison, because the whole economic program, but especially the bank, seemed built to aid and empower the more commercial North at the expense of the more agricultural South. So as a result, Madison, who had been Hamilton's ally, they had been co-authors of the Federalist Papers, joined with Jefferson in opposing this plan in Congress. So the battle lines were very much drawn. Importantly, though, for much of this debate, it was a political and ideological struggle and not a constitutional debate. For much of 1790 into early 1791, it was really a debate over competing forms of republicanism, the virtues and vices of commerce and agriculture, respectively, and thus the policy advantages or disadvantages of following through on Hamilton's program. As late as January of 1791, when the bank was debated and voted on in the Senate, the debate took this form. It was a political, ideological policy debate. But everything changed when the bill went from the Senate to the House of Representatives. Recognizing that Hamilton's plan clearly had the votes, there was a clear majority to approve of the bank in the House. At the 11th hour, and I really mean the 11th hour, Madison changed course from debating the bank's utility to issuing a constitutional challenge. Nowhere, he argued, did the Constitution give Congress the authority to issue charters of incorporation. The bank was unconstitutional. Maybe the bank was good, maybe it was bad, but that didn't matter. It exceeded the powers that the Constitution gave to the national government. And this was because, as Madison famously said, the essential characteristic of the government set up by the Constitution is that it is composed of limited and enumerated powers. The Constitution was not a general grant of power to the national government that it set up, but instead a limited grant of specific powers, each of which was expressed through precise textual enumeration. Federal power came enumerated in list form. The national government could only do what was on that list. And nowhere on that list did the Constitution give the federal government a power, an enumerated power to charter a bank. So Madison argued, Congress simply did not have the authority to follow through on Hamilton's plan. Now, bank supporters were initially quite surprised by Madison's 11th hour challenge. He had had much time to talk about the bank prior to this and hadn't said anything about its constitutionality. But they recognized that they had to take these arguments seriously, not least because Madison possessed such a formidable constitutional presence and intellect. So the very first person to answer Madison was probably my favorite congressman, Fisher Ames, the young Massachusetts lawyer, who was in no way intimidated. His supreme sense of self-regard and acerbic wit cured him of all deference. He once began a letter to a correspondent from whom he had not heard from in some time. Are you dead, sick, or married? This personified Fisher Ames's acerbic wit and his eagerness to tweak various people. And he was happy to do this with Madison because he found his argument completely misguided. Congress's powers was certainly not unlimited, but it also, Ames thought, was most certainly not limited to expressly enumerated powers. As he explained, Congress may make laws conformably to the powers plainly implied, though not expressed in the frame of government. We can scarcely proceed without the doctrine of implied powers. So were the national government's powers limited to those enumerated, as Madison claimed, or did the national government enjoy implied powers that exceeded the sum of the enumeration, as Ames claimed? And this question, posed in February of 1791, was not posed in a vacuum. It neatly revived the debate over the scope of national authority under the Constitution that had been raging since the Constitution itself was written. And this was something Madison himself had alluded to. In controversial cases such as this one, the meaning of the parties, if we can collect it from reasonable evidence, is a proper guide. We should answer this question in part by returning to contemporary and concurrent expositions of what people thought the enumerated powers of the Constitution meant way back when in 1787 and 1788. So what powers did the Constitution's framers intend to give the federal government? Well, this was no easy question to answer because the delegates to the Constitutional Convention clearly were not of the same mind. Most everybody at the convention agreed that the national government needed more power than it currently possessed. The power it enjoyed under the Articles of Confederation, the nation's first national constitution, had proven woefully inadequate. So it needed more power than this. But people certainly didn't agree on how much power the new government should be assigned. Some delegates at the convention were committed nationalists. They really believed that the national government needed far-reaching authority to address the problems that revolutionary governance had brought forward. Other delegates were wary of giving the federal government too much power. They thought that the government's powers needed to be expanded, but they were very wary of expanding them in such a way that they would trench on the existing powers of the state government. They still thought most meaningful domestic powers should be retained by the states. So everyone thought there should be more power, but how much was a source of disagreement. And this disagreement at the convention introduced ambiguities into the final version of the Constitution. The working proposal for national legislative power had initially been this one laid out in the Virginia plan, so-called Resolution 6, because the Virginia plan came as 15 resolutions, and this was the 6th one. It said that the national legislature ought to be empowered to legislate in all cases to which the separate states are incompetent or in which the harmony of the United States may be interrupted. So rather than enumerating national power, what Resolution 6 did was it identified a general class of powers that fell beyond the auspices of what state governments could do. And as long as it fell into that domain, the national government could act at it. Initially in the convention, this was met by some protests. Some people said, we can't possibly give the new Congress this much power. We need to enumerate power instead. This is an indefinite sweep that can extend to everything. Importantly, though, a lot of delegates rejected this argument. Some said it was simply impossible to enumerate power. And even James Madison said enumeration was attractive to him in certain ways, but upon reflection, he thought it was basically impractical. You really couldn't enumerate powers in a complete way, so you needed something more than that. So there were protests, but Resolution 6 stayed in the Constitutional Convention draft until halfway through the convention, at which point the convention adjourned, leaving the appointed five-man committee of detail in charge of compiling a final draft of the Constitution. And the committee replaced Resolution 6 with an enumeration of legislative powers, which eventually became the famous enumeration that makes up Article 1, Section 8, that lists a series of things that Congress can legislate on: the power to lay and collect taxes, the power to borrow money, to regulate commerce among the several states, to coin money, to raise armies, so on and so forth. So how was this change from Resolution 6 is in to the Committee of Detail removes it in the first draft of the Constitution? How is this to be interpreted? We don't know very much about why the Committee of Detail made the changes that they did. So we're left in some ways guessing. Had Resolution 6 been deleted, had this broad grant of authority been dramatically narrowed, or was the enumeration that replaced it merely illustrative or meant to carry into effect the general principle that had animated Resolution 6, that the national government had an inherent power to handle all problems of a genuinely national nature, those problems that the separate states were incompetent to address. This uncertainty about whether Resolution 6 had been deleted or merely updated was compounded by what now punctuated the enumeration, what the Committee of Detail, what James Wilson, a committed nationalist, made sure to add, the necessary and proper clause. So at the end of the enumeration, Congress can do this, 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 and this. It said Congress shall also have power to make all laws which shall be necessary and proper for carrying into execution its other powers. Now, importantly, it wasn't just for carrying into execution the foregoing powers, i.e. the enumerated powers. It also included this other addition, and all other powers vested by this Constitution in the government of the United States. What were these all other powers? What were the foregoing powers? What were the all other powers? What made something necessary and proper? Was Resolution 6 alive? Was it dead? All of this was unclear. I think what's fair to say is that different delegates could read different things into this based on what they preferred, and that's what they did. Southern delegates had put the convention on notice that unless the convention respected the institution of slavery and prohibited the federal government from interfering in it, they would not be able to support the Constitution. And many of those Southern delegates had called for enumeration. So they probably thought the power was enumerated and Resolution 6 had been deleted. But Resolution 6 had commanded a majority to that point, and nobody said anything when the Committee of Detail unveiled its draft. There was not a murmur of protest. When they got to the necessary and proper clause, there was basically no debate at all. So it seems clear that at least some nationalists didn't say anything because they didn't see anything problematic here. The enumeration plus the necessary and proper clause, especially this all other powers clause, gave them pretty much everything that they thought Resolution 6 had provided anyway. Probably the best way for us to read it is that people who disagreed recognized this and agreed on something sufficiently ambiguous that there could be consensus, and they would kick the can down the road. They would have these fights on another day. Because what they had settled on was clearly controversial. It immediately became a source of sharp debate during ratification. And they got a taste of this right away at the end of the convention when the three non-signers of the Constitution, Edmund Randolph, George Mason, and Elbridge Gerry, said that the reason they couldn't sign the Constitution, the chief reason, was because of the indefinite power that it gave to the national government, particularly through the necessary and proper clause, or what they also called the sweeping clause. The sweeping clause, as George Mason put it, absorbs almost everything by construction. This was a license for people who had power under the necessary and proper clause to expand it indefinitely. This was the argument anti-federalists made over and over and over again. Few things were more threatening than the necessary and proper clause. This was the recipe for legislative tyranny. This was the recipe to ensure that this would not be a confederacy of relatively autonomous states, but would allow the national government to swallow up the state governments and consolidate all authority for it. Federalists, acting in a political environment where they were trying to get the Constitution ratified, downplayed the necessary and proper clause, kept pointing to the enumeration and said things like, look, only those powers delegated are those we can exercise. But this, of course, begged the question of how powers were delegated. Were they expressly delegated or not? Some Federalists used expressly, others made sure to avoid it. Either way, anti-Federalists were not in any way convinced that they thought the national government had all the powers it needed to extend them indefinitely. So they called for a series of amendments. Among the amendments they called for was for something like Article 2 from the Articles of Confederation to be put into the Constitution. Basically, a remainder of power provision that said anything that has not been expressly delegated is retained by the states. When this amendment was ultimately added to the Constitution by the first Congress in the summer of 1789, though, something happened. What eventually became the 10th Amendment no longer had the word expressly. The powers not delegated to the United States by the Constitution are reserved to the states respectively or to the people. Former anti-federalists were incensed. They said, how do you remove the word expressly? That's the whole amendment. That needs to be put back in. But former Federalists who controlled the first Congress were not eager to revive the sorry days under the Articles of Confederation, so they carried the day ensuring that expressly would not be there. This amendment, the 10th Amendment, at the time the 12th Amendment, because the original First and Second Amendments weren't ratified. The 10th Amendment, as we call it, its ratification was pending with the states in February of 1791, when James Madison insisted on the floor of the House of Representatives that the Constitution's essential characteristic was that it established a government of limited and enumerated powers. So this debate that Madison was entering into, this debate was very much picked up on the debate I've just been talking about that had been raging since 1787. The National Bank picked up this debate and extended it in a big way. So the debate was consistent. This debate had been happening from 1787 to 1791, but the same could not necessarily be said for some of the participants in the debate about consistency. It was more than a little ironic, especially to people at the time, that Madison was insisting that the national government stay close to its enumerated powers. Not only had he doubted the practicality of enumeration at the convention, but he also had played a significant role in keeping expressly out of the soon-to-be 10th Amendment. And his congressional colleagues were quick to remind him of this. They were especially eager to remind him of the arguments he made in the removal debate less than 2 years earlier. How was it that executive power could be given this capacious, broad reading and all these implied powers found in it, but yet the legislative enumeration was tight and circumscribed? Madison was happy to return the fire, especially when it came to one particular supporter of the bank, Elbridge Gerry. Gerry had opposed the Constitution because, as Madison had reminded him, he had once thought its powers dark, inexplicable, and dangerous, as Madison said. But now it seems like Elbridge Gerry is happy to endorse the doctrine, Congress may do what they please. Now, Madison and Gerry were not the only congressmen undergoing a metamorphosis of sorts, and it's easy to read these transformations in a cynical light. After all, they were politicians with personal partisan interests in a partisan environment. James Madison represented a region strongly opposed to Hamilton's financial plan. Elbridge Gerry from Massachusetts represented a region that was strongly in favor of it. But whatever might have motivated their arguments, the arguments were serious and substantive, and they pushed an important debate forward. Even if they were pursued for completely disingenuous reasons, the arguments have had a profound afterlife in American constitutional history. And even if people are not proceeding in good faith in a partisan environment, you still have to answer their arguments. So the debate began in the House of Representatives, but it was concluded in President George Washington's cabinet. After the House finished its debate, the bill was sent to Washington, and he had this choice. Either he would sign it into law or to veto it. Because of his close friendship with Madison, he took the constitutional objections that Madison had raised very seriously, which led him to solicit opinions from leading members of his cabinet, from Attorney General Edmund Randolph, Secretary of State Thomas Jefferson, and Secretary of the Treasury Alexander Hamilton. And in many ways, the cabinet merely picked up on the House debate, expanding and amplifying on arguments that had been made there. Randolph and Jefferson saying, like Madison, like all the Virginians, the bank is unconstitutional. Hamilton pouring everything he had into a 13,000-word dense report that explained why it was constitutional. So the arguments carried over from one to the other. So what were those? How did bank supporters in the House answer Madison's challenge? How did they deny this claim that the national government's powers were limited to those enumerated? How did they defend implied powers? Well, first they focused on the necessary and proper clause itself, and for a period of time turned the House debate into a dispute over the meaning of these two words. What was necessary? What was proper? What did it mean to say these things? What made something necessary and proper? And what bank supporters were adamant about is that these words needed to be interpreted broadly. Opponents of the bank had defined necessary to mean only that which was absolutely essential. Few people did this quite as emphatically as Jefferson did in his opinion, but Madison and others did this on the House floor as well. And those like Alexander Hamilton thought that this understanding of necessary defeated the entire purpose of the necessary and proper clause, which had been to afford the government sufficient flexibility and discretion to tackle the very challenges that would present it to. Necessary was better understood as something closer to fairly applicable, but certainly not absolutely essential. This was also why Hamilton said there was a huge difference between express powers, things written in the Constitution, and delegated powers, which was a combination of what was expressed and what was delegated. This also led people on the House floor to return to the ratification debates, which led to this wonderful episode in which Elias Boudinot of New Jersey quoted from Federalist 44 at length on the House floor. Federalist 44 explaining why the necessary and proper clause was in the Constitution and making very clear that the meaning of necessary and proper was not simply what was absolutely essential. Now, what made this amusing was Boudinot thought Alexander Hamilton had written Federalist 44. He thought he was presenting Hamilton's position to the House, but Federalist 44 had actually been written by Madison. So we're treated to this moment where Boudinot is reading Madison from 1788, refuting Madison from 1791, and the only person who knows that this is happening is Madison himself. So having made this argument about what necessary and proper meant, this then led bank supporters to emphasize what they assumed the necessary and proper clause revealed more broadly about the Constitution. This became their bigger argument, how it transcended these narrow textual readings. As they put it, the necessary and proper clause not only confirmed that the Constitution implied licensed implied powers, but it was a reminder that no Constitution could ever be truly complete. Human beings could not anticipate all imaginable contingencies. Even the most perfect system would leave gaps. As Theodore Sedgwick said, probably no instrument for the delegation of power could be drawn with such precision and accuracy as to leave nothing to necessary implication. Or as John Vining said, the Constitution was a dead letter if implied powers were not to be exercised. This was why the necessary and proper clause had to be interpreted liberally. Ultimately determining whether Congress had the power to act required an indispensable degree of human judgment. The Constitution could not on its own specify complete rules for its own usage. So in many ways, bank supporters revived the argument that some advocates of presidential removal had defended that carrying the Constitution into effect called for congressional judgment and discretion. The Constitution was necessarily incomplete. They played with the word necessary a lot, and this was perfectly fine. Bank opponents, led by Madison, responded in force, themselves eager to draw out the deeper meaning of the necessary and proper clause. If necessary, in fact, meant, as Madison translated it, unlimited discretion, then that defeated the entire purpose of having a written constitution in the first place, as Michael Jennifer Stone, as Maryland, put it. Now, if the principles now advocated are right, it is the duty of the legislature of the Union to make all laws, not only those which are necessary and proper, but apparently those which are convenient, expedient, beneficial to the United States. And if this is so, then where is your Constitution? Is it written? No. Is it among the archives? No. Where is it? Where is the Constitution found, literally? Well, it is found in the sober discretion of the legislature. It is registered in the brains of the majority. He finished with the injunction, we must respect the sacredness of the written compact. The language of sanctity began entering American constitutional discourse in a big way at just this moment. Drifting from the Constitution's words was no different than ignoring the Constitution itself. Madison had said, we have to stick close to our, quote, chartered authorities. The national government had the authority to pass all laws necessary and proper, merely to carry out its express ends that had been expressly enumerated in the Constitution. So this back and forth about what the necessary and proper clause really meant exposed an even more fundamental disagreement. The two sides disagreed about not only means, but also the ends themselves. That is, not only did they disagree about the discretion Congress had to determine which means were necessary and proper, they also disagreed over which ends the national government could legitimately pursue in the first place. Those who were opposed to the bank claimed that the national government could pursue only those ends enumerated in the Constitution. That was the point of enumeration. Why would you enumerate unless that was the purpose of enumeration? It was to precisely define and constrain. You defined those areas where the federal government could act, and by absence, left out those areas where it couldn't act. But bank supporters completely disagreed with this argument. The ends of national governance were not narrowly confined to the list of enumerated powers. The ends of national governance were much broader than these. They were the inherent ends of national governance themselves. If a problem was, by its nature, inherently national in character, then the national government had an implied right to pursue it. As Fisher Ames said, by the very nature of government, the legislature has an implied power to execute the ends for which that government was instituted. What were the ends for which the government was instituted? Not what was found in the list of enumerated powers, but what was found in the Constitution's beginning, the preamble, which in addition to specifying that a national people, we the people of the United States, had entered into social compact, also specified a series of concrete purposes for which this Constitution was being ordained and established. None more revealing than to promote the general welfare. Bank opponents like James Madison were simply looking in the wrong place when they were trying to figure out the ends that the Constitution had specified. So what bank supporters were really saying was that the United States was a nation. And because it was a nation, it necessarily came equipped with certain implied national powers. Alexander Hamilton made this argument rather emphatically in his bank opinion. The national government had, by definition, as one bank supporter revealingly argued at one point, all of those powers that the separate state governments were incompetent to exercise. So in other words, a member of Congress basically regurgitated Resolution 6 from the original Virginia plan and said, why do we, as members of Congress, have a right to charter a national bank? Because we have a right to do anything that the separate states themselves lack the competence to do. And no state government could set up a national bank. How on earth could a state regulate a national bank? You'll never believe who made this argument, that apparently Resolution 6 had survived and had given the national government this astonishing sweep of authority to meet all national issues, none other than our friend William Lawton Smith, who had somehow overcome his misgivings in the removal debate that when the Constitution was silent, when the Constitution's text did not expressly permit something, you dare not act, to now, as an arch supporter of Hamiltonian federalism, was perfectly happy to say that in fact, the national government's powers vastly exceeded the enumeration and began and ended with what was hinted at in the preamble, that because this was a nation, whatever powers were national in nature could be pursued by the government. Also in this vein, Banks supporters echoed the Declaration of Independence. This was a debate over federal union, first and foremost, and then secondarily, constitutional interpretation, because what had the Declaration of Independence done if not created a sovereign nation with the powers of a sovereign nation? And all the Constitution was, in sort of the two-step process of social contract theory, step one is you set up a political community, we the people of the United States, not we the people of the separate states. And step two is you draw up a constitution of government for that community. Because that community was a nation, there were certain powers that automatically came with it. So at the end of the day, this was really the debate that the bank debate threw up into the air. The nature of the federal union itself. Bank supporters were claiming the United States was a nation, and that was why the national government had the implied power to charter a bank. That was what the necessary and proper clause was all about. That was the right way to understand the enumeration. Bank opponents were claiming something very different, that the United States was a federal union of relatively sovereign states, and that was why the federal government could only exercise its expressly enumerated powers. In many ways, this became a debate over the meaning of the preamble. After hearing Fisher Ames and John Vining and others, Elbridge Gerry, John Lawrence say, the preamble, the preamble, the preamble, the preamble. Finally, Michael Jennifer Stone said, well, I guess there was no point of having the rest of the Constitution. He pointed to the preamble and said, here is your Constitution, here is your Bill of Rights. This apparently tells you everything. So the debate over the meaning of necessary and proper, therefore, pointed to a much larger debate that had in some ways been the most dominant debate since the Constitutional Convention. What was the United States, and based on that, what powers did it have? These questions of what the Constitution did or did not license, whether it did or did not come with implied powers, and what those implied powers could be directed toward, ultimately required people to return to this thorny initial question that would eventually become the primary point of debate in the famous case, Abraham Lincoln v. Jefferson Davis. Was this nation born a single union, or was this union born a series of independent states that of their own accord confederated and ensured that the resulting government would only have those powers expressly enumerated? I'll stop there.
Well, thank you, Jonathan. I'm struck by this this emphasis on the preamble. It's almost like the preamble is the last refuge of a scoundrel in this debate. I think most of us, we in some part dismiss the preamble as not that important constitutionally. So I really did appreciate your laying out this. It's a philosophical discussion versus this attempt to be a precise constitutional discussion. So thank you for that. I appreciated that. Other quick question, because I want to, other quick questions that we might have before we break. Well, let's, I will say that when we come back from our document discussion session, if you need to get on to the rest of your Saturday, we won't think any less of you for.
I'm happy to be here. Happy to talk about this.
Right.
And I'll just quickly say, Tim, if it's all right, what you said about the preamble is, I think, of essential importance. The preamble has been deleted from the Constitution. It is probably the most famous part of the Constitution in terms of what people know, but it is taken to have no legal content.
Yeah.
people at the founding believed strongly that it had enormous content. And I'm actually in the midst of trying to sort of
Right.
figure out the history of how it was deleted. But this, the idea that it's just throat clearing is a really interesting way in which original meanings get removed.
Well, Lily, if you could move us into the document sessions.